Hello and welcome. I'm Oonagh Fitzgerald, President of the International Law Association of Canada, ILA Canada, and Senior Fellow with the Human Rights Research and Education Centre at the University of Ottawa. And I have the pleasure of moderating this interview with Meg Kinnear. In keeping with Indigenous protocol and building respectful relations between Indigenous and non-Indigenous peoples of Canada, let me begin by acknowledging the traditional territories of Indigenous peoples. We're meeting virtually across Canada and beyond, so I would like to acknowledge that the Indigenous peoples are the original occupiers, traditional stewards, and inherent protectors of the lands and waters called Canada today. Nous sommes reconnaissants de vivre, d'apprendre de cette terre et d'en profiter, et nous nous engageons à la décolonisation dans nos vies personnelles, nos entreprises, nos organisations, nos écoles et dans nos communautés. Les engagements que nous prenons dans cette reconnaissance des terres doivent être activement poursuivis et s'accompagnent de la conviction que la décolonisation commence par la réconciliation avec tous les peuples autochtones, y compris les Premières Nations, les Inuits et les Métis. Reconciliation, if it is to be successful, we must continue to deepen the ways in which we listen to, learn from, and support Indigenous peoples and their resilience, resistance, and self-determination. The International Law Association of Canada is the Canadian branch of the International Law Association based in London, England, and founded in Brussels, Belgium in 1873. With over 4,500 members worldwide, our collective objective is to promote the study, clarification, and development of international law, both public and private, and the furtherance of international understanding and respect for international laws. Where the International Law Association is comprised of legal scholars, legal practitioners, students, and policy makers. It's a global network, and its regional and national branches contribute to the work of ILA research committees on important topics of international law. They also hold biennial conferences. The last one was in Athens, Greece, in June last year, and the next one in Vienna, Austria, in the following year, 2026. The ILA organizes panels and workshops on a wide range of international law topics, such as the one on international law practice that we're having today. And I invite you to visit our website, join ILA Canada. Membership is free for students. Now, it's my pleasure to introduce you to our main speaker today, Meg Kinnear, and Svetoslav Ivanov, who is going to make a commentary about Meg afterwards. Meg Kinnear is the founder of Lowe & Kinnear Dispute Resolution, a firm of dispute neutrals founded in July 2024 and operating from Toronto, Ontario and Washington, D.C. From June 2009 to June 2024, she was Secretary General of the International Center for Settlement of Investment Disputes, ICSID, in Washington, D.C., and a Vice President of the World Bank. Prior to this, Meg was the head of the Trade Law Bureau of Canada, an executive assistant to the Deputy Minister of Justice, and counsel in the Civil Litigation section of Justice Canada. Meg's career has focused on various international issues, in particular international trade and international investment law. Svetoslav Ivanov is a Doctor of Civil Law candidate at McGill University with a background in comparative and international private law. His current research focuses on the ethical responsibilities of party representatives in investment treaty arbitration. He's especially interested in whether the investment treaty arbitration process can foster a shared professional ethos in the absence of codified rules of conduct. He is one of the inaugural student members of the ILA Canada board, serving as Joint Secretary. Now, before we start with questions from Meg Kinnear, I just would like to mention a few caveats. We will be asking her questions about her career, but because she was a public servant, there are certain things she cannot discuss. And also as a former executive of ICSID, there may be some things she can't discuss. So she won't be able to disclose information that is solicitor client privileged, subject to the Official Secrets Act, or relating to any ongoing cases in which she was or is involved. So in terms of logistics, you know that we have a Q&A function on the Zoom webinar. Please feel free to pose questions in English or French. Vous êtes invité à poser vos questions dans la fonction des questions et réponses Zoom. N'hésitez pas à poser des questions en anglais ou en français et nous faisons ce que nous pouvons pour répondre. Okay. And let me give a shout out to my colleague on the ILA Canada board, Barry Leon, and the TDM OGEMID for publicizing this event. And we're delighted that young OGEMID have provided several questions for Meg Kinnear, which I will raise throughout this event. So in this interview, we'll be discussing 4 big themes. One, Meg's career and any career advice she's prepared to share with us. 2, her work at ICSID. And 3, criticisms, challenges, and changes in the field of international investor state arbitration law. 4, the future of ISDS and international law. So it's going to be a far-ranging discussion. And afterwards, we'll have wonderful commentary from Svetoslav to finish up. And then I'll wrap up just before 6 o'clock tonight. So let's get started, Meg. Let's start with your career. Can you give us an idea about your early career, how you began your career in law? Yes, tell us a bit more about that.
All right. Well, I started in law probably because, unlike the rest of my family, I had no scientific aptitude. So I was a bit of an odd duck for our family. I did law at McGill, which was tremendous. And I had some wonderful professors there. For example, Erwin Kotler, who got me very interested in constitutional law, Rod MacDonald in administrative law. So I really enjoyed my time at McGill. I think almost ironically, at the time, and I don't think I'm that old, but at the time, there were no courses in international trade, no courses in international arbitration, and no courses in investor state. So I think that's sort of a bit funny, given that that's what I spent most of my career doing at the end of the day. I also think it's a bit ironic that I took the introductory course at McGill in international law, and I have to say I found it a bit frustrating because it was just so amorphous and I couldn't find any sort of way that there would be a guaranteed compliance with the ruling of a tribunal or a court. So I didn't take to it from the very beginning, I can say that. And I really chose to do the administrative law route and ultimately went to University of Virginia and did a master's there, and then came back to Canada, where I did my articles in Ontario, and then started at the Department of Justice, where in fact Oonagh and I were colleagues at various times doing various different jobs, which was tremendous. I had a tremendous job at Justice, which was really an entry-level job working for Brad Smith, who at the time was the Associate Deputy Attorney General. And he did a lot of Supreme Court practice. So for someone brand new who wanted to do advocacy, it was an extraordinary opportunity to come in and to work with someone doing the most interesting cases at the top level. At the same time, they also gave us some of the smaller cases, which was also fabulous because you really got a lot of that hands-on experience. So I kudos to the Department of Justice for having brought that kind of an intake job that I think brought in a lot of excellent litigators into the Department of Justice. And for me, it morphed into a full-time position as a justice litigator. And I have to say, along the lines of career advice, I still say to people who ask, if you have an opportunity, work for government. It is the most amazing, interesting kind of job. And I know that I think every lawyer I know who's worked at Department of Justice or otherwise in a legal capacity will say, I got hooked on the work. And it's so easy to get hooked on the work because it's so interesting. The other thing that I think is fabulous about a government career is that by and large, you get a lot of responsibility. And I know I would often look at colleagues I'd gone to law school with in the private sector and realize I was getting a lot of responsibility early on, doing things like the Court of Appeal and not just being sort of in the back of the room. So I highly recommend that if you have the opportunity. After Department of Justice for about 10 or 12 years, I changed into something that, or after litigation, I changed into something that was quite different, which is I went and became the executive assistant to the Deputy Minister of Justice. And that was a very new vista for me. Instead of being a litigator, basically doing what litigators do and coming up with a strategy and representing a client's viewpoint, all of a sudden I was in a position where working for the deputy, we were sort of the linchpin between the department and all the various policy work it did, and the Minister of Justice and her office or his office over time. And it gave me a really interesting new perspective on how government makes policy, how we had to be true to the law, but also true to the policy directions. And I think that was an amazing experience. It was also my first management experience, running the small but very unique office of the Deputy Minister of Justice. So that was a really good new set of skills that I developed. After about 3 years, I decided I wanted to go back to the advocacy and the litigation. And the deputy at the time, Morris Rosenberg, who was absolutely amazing, and I learned so much from Morris, said to me, there's this place called JLT. And Morris, in fact, had been one of the Canadian negotiators on the original Canada-US free trade negotiations. And he explained to me that there was this joint unit of foreign affairs and justice lawyers called JLT, and that they were doing all this interesting trade work, and he thought I would really enjoy that. It sounded amazing to me. I have to say that I knew nothing about trade law at the time, so it was also a very lucky thing. And I put my head down and studied and worked really hard to understand all of these new terms and new rules, and went over to the Trade Law Bureau. And at the time, Canada's Trade Law Bureau was working mainly on classic trade and WTO type dispute settlement. And they were a tremendous, really experienced group. But what was happening there was that they were starting to get the first NAFTA Chapter 11 cases, which of course were the investor state cases. And so all of a sudden we had to make sure we had the staff and the technology, and we had to say, how does Canada present itself and defend itself in these cases? So my litigation background came in very handy at the time, but I also have to say there was a lot of learning on the job, and that was a great experience. So I did that. I did a number of investor state cases, and I was also involved in negotiation of a number of investment treaties, and in particular, a big treaty for Canada, which was the 2006 Softwood Lumber Agreement. And again, another thing I will note, if you ever have the opportunity to do negotiations for a government, it is again an incredible experience. It's a really different experience than advocacy, because you are in many ways sort of trying to jointly develop something that works for everybody, as opposed to trying to be right and not wrong. So it's trying to find what's right for everybody. And it's an incredible experience where you get to work with colleagues from all sorts of different governments. So again, if you have the opportunity, highly, highly recommended. I stayed there for 10 years. And at a certain point, the World Bank advertised for a Secretary General. The World Bank ICSID is the primary investment arbitration facility. It's done about 75% of all investor state litigation, and really is the center of expertise. So for someone like me, it was an opportunity to go to what seemed like the center of the universe professionally. And ICSID, interestingly, decided to get a full-time Secretary General because it had, in its own way, felt what was happening in the investor state world, which was there were a number of new treaties, basically the end of the 1990s, early 2000s. There was a huge increase in these investment treaties by many, many countries, and almost all of them had this investor-state dispute settlement. And so, not surprisingly, we were starting to see more investor-state dispute settlement, and ICSID's case law was going up, 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 and the World Bank president decided it merited someone whose job full-time was ICSID and taking care of that organization. So I applied on an international recruitment. I had to be elected by the members, which was, again, an interesting experience. And ultimately, lucky for me, I was successful and came to Washington in 2009 and did that job until this June 30th. So I did that for 3 terms and 15 years. So it was an incredible experience. So I have to say I've been very, very lucky at the opportunities that have come up, and they all one sort of, works with the next. I think that's been an absolute blessing, and I can't say it's due to brilliance. I think I've been just really very lucky in many respects.
I'm going to jump in now because I know there are a lot of questions about for young people, and of course every generation is different. There's always different challenges for them. And so I have a number of questions about careers in law and in international law. And if I could just, I'll read them to you. So one is like, what advice do you have for law students and early career lawyers who are thinking about pursuing a career in international law? And I just want to mention specific questions from young Ojamid listeners. One, anonymous, asks, is it worthwhile for young people to pursue a career in ISDS, given the multiple challenges that ISDS is facing? No specificity about that, though. And then another question was from Iskren Radoslavov, and he asks, given the competitive nature of the international arbitration field, young professionals need proper guidance. How can young professionals find a mentor in this field? How can they build a strong profile and stand out in the international arbitration community? And then another question really about Canadian law students, if you've got any particular advice for them.
So. Absolutely. So if you are interested in this field, I'd say 100% throw your hat in the ring and go after this opportunity. It is obviously still something new, and yes, it is very competitive, but there are opportunities, and I think what you have to remember is you need to be very flexible. So take the opportunities you can, and one will lead to the next. Get the skills that you can. No, I think it's difficult for anyone starting out to have 100% diet of investor state. That's pretty rarefied, but you can get incredible skills doing commercial arbitration, doing commercial litigation. So all those skills accumulate, and I think will make you a very good investor state lawyer. I think that there are many times when jobs are outside of Canada. That's just sort of how the profession is. There are a number of incredible Canadian practitioners, and more we're seeing Canadian practitioners who have been able to have successful practices in Canada, which is fabulous. But I think by and large, you still find that there are some hubs like London, Paris, New York, Washington, increasingly Singapore and Asian hubs. And so be open to potentially spending part of your career somewhere else. I think that happens to be actually one of the best parts of this whole practice, which is you can do this in so many places and learn so much in so many places. But the idea is flexibility. The mentorship is also, I think, a really good point that's been brought up. And it is important to have not just one mentor, I think a lot of mentors, and you will get mentors as you work through your career. At ICSID, for example, we had a number of internships. So take advantage of if you have one of those kinds of internships to get to know the senior lawyers, the deputies, the Secretary General, and they will become your mentors. I think there's probably nothing more flattering than someone asking if you would be their mentor, and I have never heard of someone saying no to that. So don't be scared to ask someone if they would mentor you, and be a person that you can talk to from time to time as you develop your career. The question about why work in investor state, I think that's a really interesting one. And I know, we're going to talk a little bit about the discipline of investor state, but I do understand there are challenges, but I think this discipline is going to get bigger and get stronger. So I've heard all of the discussion about backlash, and we're not going to have investor state anymore. To the contrary, if you look, the cases continue to increase, and we've seen the number of, for example, member states at ICSID. When I was there, we had 18 new member states in 15 years. When I first came in, there were about 20 new cases a year. Now there's regularly 55 to 60 new cases a year. So you hear the discussion about this is a dying field. The reality on the ground is it's not at all a dying field. In fact, it's very much a growing field. So I would not be concerned from that perspective. What I think you can also say, though, is that it is an evolving field. The investor state of 25 years ago is very different, and I think investment law and practice has really grown to meet a lot of those challenges, and I think we'll keep doing it. But I think it's a great place to have a career, so I would not be concerned about that.
There was another question related to careers, and that was for the more seasoned lawyers. They were wondering, how do you, any particular advice for somebody who's been practicing for a while and they want to have greater success in their career in ISDS? What would you suggest to them?
And I mean, as counsel or as arbitrator?
Yeah.
Well, it's interesting because I think that's probably one of the questions I've been asked the most in the past 15 years. And now that I am available and working as an arbitrator, it's a question I sometimes ask myself. So I know it very well. And as I've always said, the first appointment is absolutely the most difficult. Once your first appointment occurs, you have a chance to prove yourself, and people start thinking of you in this discipline. But I totally understand the first appointment is very much the toughest. How do you get these appointments? Well, obviously there are some knowledge prerequisites, and it's not just international investment law, but really good to have a grounding in public international law, a grounding in arbitration and procedure. All of those kind of skills are important. And I think it's also very important to be visible in this field. So I know, there are lots of capable people, but the fact is about 75% of the time, it is the parties who are making the nominations. So the parties and their counsel have to know that you are capable, that you know the field, you're available, and would like to be doing that kind of work. So this idea of visibility is really important. And sometimes it's hard because we're talking visibility for practitioners who are all over the world. And you sort of think, how do you do that? But it's really, really important to be visible so that people think of you when new appointments come up.
Would that be things like writing articles and
Absolutely.
on panels, that type of thing?
Absolutely. I think all of those things are good things. And, for sort of the younger people, I've seen people actually sort of volunteer to help run an investor state conference. It's just getting out there, talking to people, letting them know that this is your field and that you are capable and competent and ready to go.
Great. Thanks for that wonderful advice to our listeners, Meg. Let's talk a little bit now about some of the formative legal files that you worked on. Please tell us about some of the, history making or less obvious files that you feel you learned a lot from. It'd be great to be able to touch on some of the big files you dealt with in the course of your career, of course, without disclosing any privileged information. And so over to you.
Absolutely. Well, first of all, I think I should say that some of the most formative work in my career was very much not history making, but it was learning the skills. So I can remember, for example, helping the criminal law people when they had what was called the X, an exhibition in Ottawa, and they were out making small arrests for marijuana, and you would go to court and have 50 dockets in a day, but what better experience is there really standing on your feet and having to respond quickly? Another one I can remember, I didn't know until we actually did this, there were all sorts of regulatory offenses, things like, believe it or not, too many fishing lines or that kind of thing. So not by any means earth-shattering, but incredible experience for a starting lawyer who gets to stand on their feet and learn advocacy. So I have to put a word in for some of the less groundbreaking ones, but certainly important for the skills development. On groundbreaking ones, I think I was very lucky at Justice to do a number of these. When I was there, the Charter of Rights was adopted in Canada. And so we started seeing challenges to a number of government programs and doing things, for example, having to develop what was then known as the Oakes test, and a number of the substantive obligations in the charter. So, for example, I worked on a case where an inmate was challenging the fact that inmates were deprived of the right to vote while they were in jail, and challenging that as a charter breach. Another very interesting case, and these are all public cases, was a case where longshoremen in British Columbia went on strike, and eventually the government passed back to work legislation, mainly based on a record of the kind of economic damage it caused to the country. And you could just see when things couldn't unload at the BC ports, it kind of backed up across the prairies and across Canada. And that was the kind of record we had to develop. So those were really interesting kinds of cases. Another one I was fortunate to work on, which was not a charter case, but was a case where the Pearson Airport was going to be privatized. And it became a very big election issue. And Jean Chrétien was then running for election and very clearly said in the media that were he to be elected, he would immediately cancel that contract. And he was elected, and he immediately canceled the contract. And so I and a number of wonderful colleagues at Justice lived with that litigation for a good 4 or 5 years after, discussing had there been breach of contract, and more than that, what the damages would be. So again, why you get hooked on this work, it's all of the sort of high profile, interesting questions, and you get to be right close to it and to do the work. So no wonder we all get hooked on that. When I went to the Trade Law Bureau, I think the NAFTA Chapter 11 cases were probably the most high profile and very interesting. I've often said that at the time, there was very little law. And now we look at investor state law and there's a ton of it. At the time, we were really scratching our heads trying to find authorities. Where do we find the law on expropriation? And usually Iran US claims. Where do we find what fair and equitable treatment is? So it was really a new field, and we were very much learning as we went along. So I think those were some of the cases that I was lucky enough to be involved with.
And what about when you joined ICSID? Can you talk about cases there? Is that a context where it makes sense? Files that you were particularly useful to you in developing your role there?
Absolutely. I think the thing about ICSID and going to that job was it was a different role. So I was no longer an advocate or making a case for a particular position. I was actually leading a group, and that group was administering investor state cases. So instead of being sort of for a claimant or for a respondent or whatever it might be, it was making sure that the institution was and remained fit for purpose. So a bit of a different role. What I found most interesting was I was actually very superficially, but involved in, I think, every case. The Secretary General has to register every case. And then, interesting situations come up from time to time in different cases. The individual cases were largely dealt with by our tribunal secretaries, but I had this sort of bird's eye view of, well, at any one time, we had between about 250 to 300 cases ongoing. And so the key thing was making sure the organization was fit for purpose and doing what it needed to do. Part of that challenge was making sure that we knew what our various stakeholders or constituents wanted and needed, and were they getting that? And there were a number of different ones. The first one, I think, was the World Bank, because ICSID is one of the 5 parts of the World Bank. And it does something very different than the rest of the World Bank. So I remember, having to sort of report into the president and vice presidents, and a lot of them would sort of look thinking, what is ICSID? So part of this was just explaining how we were part of the World Bank, how we fit into its overall mission. Other constituents or stakeholders were our member states. We had, I think, about 158 member states by the time I left. So making sure that they all knew what we did, what we could do, that kind of situation. And then very much the lawyers and their clients who were actually doing cases at ICSID. So you have a number of distinct stakeholders who all have different interests, and it was making sure that you were addressing all of those.
Fantastic. Okay, so we're going to move to the next section, which is looking at some of the criticisms that have been leveled at the ISDS system. And of course, I think most people on this call, this webinar, would know that Meg Kinnear is a strong proponent of ISDS. But my own experience is that in most groups of people who are deeply interested in ISDS, there are definitely some skeptics with some strong criticism. So I thought it would be really useful to hear from you what your thoughts are on some of those, some of those issues that have been leveled against investor-state dispute settlement, and just engage you on some of these thorny issues. So I thought maybe a first one to raise was just this, and this is actually more of a positive, but especially in this time when we're seeing a lot of sort of ignoring of international law, it's kind of useful to go back to first principles of the UN Charter. And we do see that this idea of peaceful dispute settlement is a really important part of the framework, as a fundamental pillar of the UN Charter. And of course, they're thinking about disputes between states, but often ISDS is kind of, it's sublimated of a state, right? It's usually it's a corporation or something challenging a state, but it without a system like ISDS, there's always the risk that the state from which that company comes would actually take on the challenge, and you'd end up with something more of a dispute. So can you talk a little bit about whether you think ISDS contributes to sort of peaceful world order or is problematic?
Yeah, no, I mean, obviously, I believe ISDS does contribute to that. There are a few cases that are interesting in that they deal with conflict and security very directly. Probably the first investor state case was a case of Tamil rebels who burned down a property. There've been a number of cases, for example, arising out of the Crimea. So what you might think is really classic peace and security issues can and do come up. But really, the basis for investor state is about trying to ensure flows of investment and foreign direct investment. And the idea behind all of this is that you try and ensure you have an investment climate which is attractive and will bring investment into your country. And this is a win-win. It is obviously a win for a country who gets investment into their country. It brings jobs, it brings technology transfer, it brings tax base. So that is that side of the equation. And obviously the investor also, if they've invested well, hopefully makes some profit. So it's meant to be a win-win kind of situation. And the idea that you have investor state means that states need to be accountable for living up to the promises they make to investors. So for example, treating foreign investors the same way they would treat domestic investors, not having a bias against foreign investors. And we know, and I think this is something that we often forget because we've gone so far in this world, but we know that one of the reasons we have this is because before there was investor state, foreign investors would find they had no remedy. They could not use domestic remedies either because they were barred from that or because a domestic remedy wasn't available or there was bias in the domestic system. They could not use international remedies because by and large that required a state to espouse your cause. And so they were left with no remedy. And that was the idea actually of getting this sort of interesting hybrid, not state to state, which was the classic situation, but investor to state. I think by keeping investor climates welcoming, by encouraging states to live up to the rules, you've done something very important for peace and security, and in particular for international well-being. The system has both, I would say, a preventive effect and a sort of fixing a wrong. The preventive effect really is states know if they don't follow the rules, they may well have to face an investor state case. And we know that a lot of cases actually are resolved. Our statistics at ICSID were that about 35% of all disputes resolved before they got to a final award. And that was after they started at ICSID. So certainly there were cases that resolved even before they got to the idea of doing some kind of formal dispute settlement. So there is kind of a preventive function to this. And then there's the other function, which I think people think of more often, which is if there is a breach of the treaty that caused damages, people have a rule of law type system, a set of rules, a fair adjudication where they put their best foot forward. And if they do not succeed, they have an obligation to comply with whatever the remedy is. So it's got both those sort of preventive and ex post facto dealing with what happens when there is a breach.
Yeah, and I've heard people say something about ISDS both as a positive and a negative, and that is that it can be like it's almost like an external constitution imposed upon states. I mean, obviously they decided to have it imposed on them, but that it serves to kind of keep within bounds the way states will behave because it has a, certain standards that have to be met. But people will argue that both pro and con. On the con side, they would say it's kind of chills the ability of the state to take action. This has come up quite a bit on issues like environmental and social issues. But as I say, I've definitely heard other people say, yes, but it also keeps our government from going off the rails and doing ridiculous things, which are going to be very bad for all of us in the end. As you say, it affects investment in our country. So I don't know if you want to say a bit more about that.
And states undertake that knowing that it's potentially, there will be investor state cases, but thinking that there is a greater good for them and that they can attract investment. So there's always sort of those both directions. I think the regulatory chill is an interesting one. I know that's one that we often hear. There is debate as to whether regulatory chill really exists or not. Some will vehemently argue it does. Some will say it doesn't. I have to say that at the end of the day, it seems to me that the role of government is to govern, and that sometimes means regulating. And sometimes you have to make assessments where you might face international arbitration. We see that with domestic arbitration. A case might well go to the Supreme Court of Canada, but it doesn't mean you can abdicate your responsibility to govern or to regulate because that's your job. So I think that's one of the things that's important. We certainly know that we have governance now that is much more complex. We've got a lot of complex regulatory schemes. And so a lot of more complex issues are raised in investor state now. But we've always had what's called the police power, which is essentially the public international law recognition that governments may and should regulate, and that, for example, it would not be expropriation where they do so in good faith. We had some very interesting cases, I think, which confirmed this. One of them was the Philip Morris and Uruguay case, where Uruguay had adopted some very assertive tobacco labeling packages with, pictures that should put anybody off from smoking, those kind of issues. And Philip Morris, the manufacturer, brought arbitration saying that this had effectively expropriated its trademark and had caused it loss of business. And one of the very important things that the tribunal did was to affirm very clearly there is a police power, and when states regulate in the public interest, as long as they do so bona fide and proportionately, they will not be found liable for a breach of the treaty. And that's been applied in a number of cases. Canada had one, Crompton versus Canada, where there was a full ban on treatment of seed by a product called lindane. And in fact, again, the tribunal found there was no expropriation because banning that treatment was something the government had done for the health of Canadians. So I think that, when people talk about chill, in fact, the right to govern is very much a part of investment law. We have also seen a number of new treaties where there are provisions that are even more explicit, saying that government can act, for example, in the interests of the environment, public health, again, as long as it is bona fide and proportionate. So this whole sort of discussion about regulatory chill, I think investment law has an answer to that and has developed to make sure that it is clear and that government's not prevented from doing what it's supposed to do.
Thanks for that. And there's another criticism that I want to bring to your attention, and that is this idea of how can it be a just system if it's a private legal system that lacks transparency? It's not always easy to find where the decisions are. One in which the public interest in civil society may not be well represented, and one in which issues of corporate social responsibility might be considered irrelevant. I know there's a lot there, but good luck with it.
And questions, we'll just go one by one here. Obviously, this is something you hear in the debate or the dialogue about investor state. I don't fully understand what's meant by so-called a private system. Certainly, arbitrators are paid by monies that both of the parties put into an escrow account, essentially. So
I'm sorry, I think part of that idea is just as opposed to the national government's the legal system of that country, the institution.
Exactly. And I guess the point there being that it's not supported by a taxpayer base. In fact, the parties have to pay for that. So in that sense, I guess it's private, but it is also not something that individual taxpayers are required to pay for. What we often hear in that context is concern about how arbitrators are nominated. And the usual way is that each party nominates one arbitrator, and then both parties will nominate a presiding arbitrator, or the two arbitrators will nominate a presiding. And there's been a lot of debate about whether this is a good thing or a bad thing. It's certainly the norm in arbitration and the norm in investor state. But we've heard lots of discussion about other ways to appoint and whether that would be better. On the other hand, we hear a lot of users of the system who say it gives them a lot of confidence in the system that they can at least nominate one of the three panel members. So it's one of those debates that's out there. I think the one that's really important is this discussion about investor state is not transparent. And I have to say, I don't think that's at all correct anymore. I know certainly at the early days of NAFTA, we heard that a lot. So much has happened to respond to those concerns about lack of transparency. So, for example, you had various measures taken by the NAFTA parties. You had the 2006 rules of ICSID, which brought in public awards, public documents, the ability to have amicus who could participate as part of the case. We went even further on the 2022 rules. And then in parallel, you had UNCITRAL doing basically similar rules, but for cases under the UNCITRAL rules, and then an international convention known as the Mauritius Convention. So so much has happened, and I think this really is, all of the tools are there for transparency. And, today you can go on the ICSID website and you can watch a hearing. We videoed many, many hearings, documents, awards, procedural orders. Those are all on the ICSID website. So the idea that it is not transparent, especially when you think of it as an international system, I don't think is correct anymore. So those tools are very much there.
Great, thanks for that. And another criticism, which I feel is probably changing quite a bit, but it certainly was the case in the past, was that ISDS was almost exclusively a kind of white male club, dominated, by a few highly paid European, British, and American lawyers, male lawyers. Your presence at ICSID, I'm sure, has been a wonderful, a model for people to see that there are women working in this field. But how has this lack of diversity been changing over the last 15 years, would you say? And is it still an issue?
Oh, it's certainly a work in progress. I think in 2009, we looked at the statistics and there were about 9% female arbitrators. And we, like many other institutions, started to try and get more diversity. And again, doing that takes some time. The institutions don't often appoint. And so a lot of it is bringing awareness and, again, visibility to the fact that there is a bit of an imbalance, that there are some excellent female arbitrators, and getting awareness about that. And increasingly, I think other arbitrators and counsel are very much aware of that. So the numbers have gotten better. I think ICSID now is at about 35% female. And so it is a work in progress, but there has been huge change and improvement in the last sort of 10, 15 years. The other important thing to remember in terms of diversity, very much, yes, it's a gender issue, but there are other forms of diversity that are also critical. For example, regional diversity, especially in an international system. It matters that you have people from every continent who are involved in this discipline. So it's all a work in progress, but I think institutions are widely recognized as having taken a real lead role in this.
That regional issue is an important one. And do you think, going back to your comments about careers, do you think that provides an interesting opportunity for people to work in these, to represent different regions or bring their skills in different regions?
Absolutely. I think it's real, and there is more opportunity than ever before. So I think so. Yeah.
Mm-hmm. Okay, I've just got two more of these critical questions, but you're handling them brilliantly, of course. So I'd like to know your thoughts about conflicts and perceptions of conflict of interest in the ISDS profession. What could you tell us about that?
Yeah. I mean, again, one of those big issues, when we did our rule amendments, which were finalized in 2022, it was one of the things that stakeholders wanted to be addressed. And in fact, at the end of the day, ICSID worked with the UNCITRAL Secretariat to work on a joint code of conduct. I think it's important to note there have always been rules to address conflict of interest in arbitration, and always been the possibility to ask an arbitrator to step down if you thought that there was a conflict, or to challenge them through a formal challenge mechanism. But certainly there have been a number of discussions about what is a conflict in terms of investor state. One of the big questions is repeat appointment, or if an arbitrator is always appointed by the same party. And you see some of those issues in commercial arbitration as well. But those are the kind of debates that we have in investor state. I think probably the biggest one has been the whole question of what's called double hatting. And that basically is when someone acts simultaneously, and this is simplifying a bit to make the point, but simultaneously as a counsel on a particular case, arguing particular law, and then in a different case, but arguing the same law. And that's called double hatting, and something that really has garnered a lot of critique in the last while. And it was something that I think for the first time, the code of conduct that ICSID and UNCITRAL put together actually addressed when double hatting would be allowed and when it would not be allowed. So that is an issue that has been addressed. I also think, frankly, there's just much more awareness now among arbitrators and counsel, and there are fewer people who are double hatters. So for example, the practice that we've just set up in June, we've said we are dispute neutrals so that we are not acting as attorneys or advocates. It's only one side of the piece. And I think you see that increasingly. On the other hand, there is a very legitimate point, which is having done the cases as counsel, or for me, I was very lucky to see all the cases as Secretary General, is extremely good hands-on experience and lets you know what these cases are all about, that they can be all over the map and that there are no set answers or no, having a biased perspective one way or the other is just unrealistic because all of the cases are very different. So having that experience is good. And I think the problem that we talk about in double hatting is just the question of doing it simultaneously as opposed to sequentially.
Mm-hmm. Okay, and the last question I wanted to ask you in this sort of critique section was about the business of investing in ISDS litigation. That is third-party funding. I know it's been quite controversial. I know you've got kind of two views on it. I'd love to hear.
Yeah, and we're going through all of the issues that we talk about generally in investor state, and third-party funding is definitely one of those. And again, was one of the big issues that the stakeholders wanted us to deal with in the ICSID rules. And again, as with all complex problems, there are arguments on both sides. And on one side, you can see it as access to justice. If I'm an investor and I have put everything I have into an enterprise in your jurisdiction and you expropriate without any justification, I should be able to at least take that to a rules-based adjudication. Third-party funding is a financing mechanism that would allow me to do that. Now, I think where people get especially concerned is they are worried that the third-party funder might be getting more involved in substance as opposed to simply a financing mechanism. And I think the other concern we heard certainly was a concern that third-party funding made it easy to start a case and so would encourage frivolous cases. And I think that should be disabused. There are separate mechanisms to address early dismissal of frivolous cases. So the fact that it is or isn't third-party funding really has nothing to do with it being frivolous. And so the rules address the sort of frivolous case, and it is not just because it is funded, or it has nothing to do, frankly, with being funded. At the end of the day, the ICSID rules brought in a new rule for third-party funding, and any party who has third-party funding has an obligation to disclose that they do have funding and to disclose who the funder is. So you can determine, is there any kind of conflict of interest that's brought up by the third-party funding. And I think that's the kind of approach that almost universally institutions have taken in the last while this discussion has been going on. We've also seen some jurisdictions who have regulated third-party funders. So again, it's one of those issues that is being dealt with as we sort of discuss, what works and what doesn't work. So there's been a lot of change there as well.
Mm-hmm. So it sounds like there's still more that may develop on that front.
There are certainly those who would like to see more develop. I don't know of any particular sort of rule changes ongoing right now there. But obviously, we're seeing how those rules work in practice, and if changes are needed, I'm certain ICSID will bring that up to the membership.
Great. Well, thank you for going through that gauntlet of questions. Well done. I just want to remind the audience that they can put questions in the Q&A, and we'd love to take them. So let's move on to the next section, which is really about the reforms that have been going on in the area of ISDS. You've certainly mentioned a few of them, but you know, in your work, you've certainly shown a commitment to strengthening ISDS over the years. We'd like to look into some of these reform initiatives in more detail, especially because the international legal system is being challenged these days. And it's nice, you know, it's good to consider what international law is developing at this time. And so let's just go through some of the initiatives that you're aware of. You talked, I guess the first one was about transparency. Do you want to talk about that? The UN Convention on Transparency in
Sure.
treaty-based investor-state arbitration?
Yeah, and I think maybe as an introduction to this, we're seeing a couple of sort of places where there is a lot of change. One of them is treaties, and new treaties have quite different language than the original treaties of the 1960s, 1970s. And I think there has been a tendency to be much more specific about the treaty obligations so that there is a real clear state intent. This is what we mean to have protected and what we could be liable for in investor state. So there's been a lot more specificity in these treaties, new issues that have come up. We've been talking about, for example, police powers, environmental clauses. That's the kind of language that we see now that you wouldn't have seen before. So a lot of the changes being done by states in the treaties. The next sort of locus maybe of where changes has been by institutions. So you have certainly for procedural change, ICSID's 2006 and 2022 amendments, which have really been quite comprehensive. And then you have the work that's ongoing now of Working Group 3 for UNCITRAL. And what was before, Working Group 2 worked on the Mauritius Convention and the changes on transparency for the UNCITRAL rules. So I think that was a real leap forward done through an international institution. And now they have what's known as Working Group 3, which has a broad agenda of various reforms. To date, they have accomplished, for example, the Code of Conduct, which they worked with ICSID on. They have got agreement to a comprehensive investment advisory group so that states, especially those who can least afford counsel, are able to get advice. And this is based on the advisory group of the WTO. And they're now working on procedural clauses. And I think their sort of next topic is structural reform and the idea that some have put forward of an international court for investor state. So you've got different locus of change. But to me, this is relatively a young discipline. Really, the first cases were 1970s, and so much has happened, and there has been so much change, which I think is notable for an international law discipline. Change is always hard in any regime, but when you're doing it with whatever, 175 states as opposed to one state, you've got a lot of stakeholders, a lot of different interests. So I think the discipline needs to be credited for how much it has evolved and addressed what it thought could be done better.
Yeah, a few years back, people seem to be just throwing up their hands in despair at the thought of those 3,500 different treaties and you know, the impossibility of getting out of it. And yet we've seen quite significant changes coming down the pipes.
Yeah.
Well, even
Exactly.
the NAFTA to CUSMA being one example, but the CETA is one, I guess, that would be interesting to talk a little bit about. The you mentioned UNCITRAL working group and the idea of a permanent court. I guess I don't know which came first.
Yeah.
Was it the Europeans who came up with that idea first? But certainly an idea that is developed somewhat in CETA and presumably has a broader audience. What are your thoughts about that? The idea of a
Yeah, it's kind of had an interesting or a funny kind of history. It actually first came up with the United States under their Trade Promotion Authority, and the US actually put the potential for an appellate body in a number of its treaties with some Latin American countries. After that had happened, ICSID actually proposed in 2006 that it might set up an appellate body, and it did basically a sort of high-level concept piece and went to discuss this and consult with countries around the world, and in fact got to Europe and was told, really, we don't have a lot of interest in that right now. Fast forward a couple of years, and what we have found is that there has been, I think, much less interest by the United States on that. And in fact, there is huge interest with the EU and EU member states. So I think it's fair to say that they've certainly been a proponent and have put the potential for a court in a number of their free trade agreements in the chapters on investment. So the world has changed a lot. This is now being addressed at Working Group 3, I think, with the idea that if that is a change that the world wants, better to have it as one that applies broadly as opposed to having to put it in each individual treaty and having it apply between potentially the two state parties. It is a complicated idea. Again, there are pros and cons, but there are some very difficult questions that arise when you get into how would this be accomplished. There are also a number of different positions that have been made public at UNCITRAL. You've got, for example, the EU, which is very keen on a two-level court with the tribunal and appellate level. You have China, which very much wants to keep the current arbitration system at what you might say is the first level or the tribunal level, but then would like to see the option of an appellate body that those decisions could all feed into. And then a number of states that say, we think iterative change is what's needed. We are seeing that iterative change with ICSID rules reform, with some of the Working Group 3 projects, some of the treaties. So you're seeing change affected in a number of different ways. And I think there are a number of states that are still trying to decide what do they think is the right answer here. But there are some really hard questions. I mean, first of all, who would pay for a court? It's an expensive endeavor. Secondly, what would it do to timeliness? If you have, for example, a full appeal, it will certainly add time. And one of the big critiques we have right now, and one of the big efforts we're trying to deal with, is time and cost. And so will it exacerbate that kind of problem? Who would the judges be? The judges would potentially be appointed by states, and yet states are always one party to these cases. Does that upset an equilibrium? One of the big pluses that people put forward for this idea is that it will increase consistency and predictability. I think there are some real good arguments that consistency and predictability is much better now. It's a new discipline, and so you don't see the same kind of huge inconsistencies that you might have had in the early days. Now, that's not to say it doesn't happen. It happens in domestic systems. It happens everywhere, but I think there is much more consistency. And the difficulty, or one of the difficulties, is that, as you said, Oonagh, with some 3,500 treaties, you're actually interpreting different law in many respects, and obviously in different fact situations. So it's not as easy as, we might want. The other thing that I worry about is their appetite for an international court. We've seen what sadly happened to the WTO appellate body, which I think many people felt was you know, the jewel in the crown and a real example of an international court. So is there the appetite to do that right now? And if not, if you don't have a core mass of states doing this, you're really just going to fragment the system and make it that much more difficult to access and that much more expensive to access. And one of the things here, which I don't think the Working Group 3 has had a real chance to look at this part now, is what happens to enforcement. And there is a very effective enforcement mechanism, in particular under the ICSID rules. And if you take various countries and treaties out of it, you will lose that enforcement. And so there are a lot of, you know, the devil is in the details for certain. And so we're going to see what happens in the next couple of years. ICSID has a 2026 deadline. This is a conversation that will, at the very least, take it to 2026.
It seems like a really complex timing problem where attitudes around the world are fluctuating wildly, because presumably the UNCITRAL initiatives were undertaken because there was a kind of growing sense that something needed to be done to reform ISDS. And yet, you know, examples like CUSMA, where we get rid of ISDS, and your example you gave of the WTO appellate body no longer being able to function because people are not appointing the members to it. It does suggest that kind of a walking away from dispute settlement. So I don't know, what do you think where are we heading?
Yeah, well, it's a tricky road for sure. I think we're moving forward, but sometimes by going left and then by going right. But I think one of the interesting things here is people talk about Canada walking away from the system, and yet at the same time, very recently, Canada adopted a model bilateral investment treaty, which is a template or a framework for negotiations, which very much adopts the tribunal model. So it'll be interesting to see sort of how that all works out. And I don't know where it goes to. This is why everybody, myself included, is keenly watching to see what happens at Working Group 3, and if a court is adopted, what the model is and how many countries adhere to that. I think that's one of the big discussions right now.
Mm-hmm.
I think also it's fair to say we have a very different world for investor state today than we did 15 or 20 years ago when this discussion all started coming up, which is why perhaps a number of states are thinking, what is my position? Do I think the pros outweigh the cons or vice versa?
Mm-hmm. Yeah, I mean, the bottom line, I guess, from my point of view would be we need to make sure we do have peaceful dispute settlement systems.
I think that's exactly the point. Peaceful dispute settlement, so effective dispute settlement mechanisms. And one of the things that we're starting to see is more dispute settlement mechanisms. And what I really mean in that sense is there's been a lot of discussion about mediation. And there's been a very successful record of mediation in commercial arbitration and in litigation. And the idea is to bring it into the investor state context. So that again was one of the things that ICSID did in 2022, was to put into place mediation rules. And so the question now, we're in early days, will be, does that succeed? Do states want to use them, and do investors want to use them? And I'm hopeful that that's the case, but we're in early days.
Mm-hmm. Yeah, that's a positive development. I have two questions from the young Ojimid. First of all, Gurtej Gruel asks, how can institutions like ICSID balance arbitrators' independence with the need for predictability in awards? Do you foresee any practical means, whether they're procedural reforms or existing mechanisms, that could address this tension?
Yeah. It's quite right that, you know, you can see how that is a tension. I think what's really critical for that is transparency. It's hard to be consistent with an award when you couldn't even read it or know it was out there. So transparency is 99% of this battle, and getting awards and orders out, I think, is really important. There is a doctrine, since we don't have a strict presidential situation as you might have in a domestic court. There's a doctrine which basically is called jurisprudence constante, essentially the idea being, where you've got the same facts, the same law, and compelling decision in a certain direction, that would be something that tribunals would follow. So it's not a hard precedent rule, but it recognizes that kind of approach is good for the stability of the system, is good to make it a system where you can predict, if I do this, is it on this side of the line or on the other? And I think that kind of doctrine relies heavily on transparency. So I keep going back to transparency, knowing what's been decided and why it's been decided is really key.
I have another question from a young Ojimid member. Ayushi Singh asks, during your time at ICSID, you oversaw significant reforms to address concerns about the ISDS system. Looking ahead, what do you think are the most important steps institutions like ICSID and the arbitration community can take to ensure the system remains fair and effective for both states and investors?
Yeah. Two issues to my mind, and I think they're both issues, one in particular that we tried to address in the 2022 rules. To me, the biggest thing that we have to do as an international investment community is to make sure we address time and cost. If the system becomes such that it takes years and years or decades to complete a case, no one will want to use it. So it needs to be much more nimble. It is a difficult question. I mean, someone says, how long should an investor state case take? And that's a really good case, a really good question. There are some very complicated ones, applying international law, complicated fact situations, complicated law, sometimes new law. And so it's hard to say, oh, it should be done in 1 year or it should be done in 2 years. But I think we really, as a community, need to be incredibly conscious of trying to make sure that everyone gets to put their best foot forward, but in an expeditious way. And that can't happen unless everyone who's a part of the system, and that means arbitrators and counsel, are very much mindful of it. So putting your best arguments forward, and not just every single possible argument. It means everybody has to discipline themselves for the sake of having a system that works well. I think obviously everyone wants a system that works well. This is especially important to make sure that it's available not just to people who have a lot of funding to do this, but also to the small and medium-sized enterprises. It should be available to them as much as any other party, and you don't want cost to be a barrier. So that's the issue. I think certainly I can say that's one of the issues that I've been very concerned about. And we tried to address it in a number of ways during the ICSID rules reform, but it is definitely a work in progress. And I know, for example, the LCIA has recently issued a paper talking basically about the same kind of thing. If we want arbitration to be, vital and to do its job and be fit for purpose, we have to address this time and cost problem. So that's one of the biggest things that I think is really, really critical that we just have to stay on top of. The second issue that I think is really important, and these aren't sort of brand new issues that no one's thought of, but I do think they're important, is enforcement and compliance. And certainly ISDS and ICSID in particular, with its special enforcement mechanism, has a very good record in that sense. But there are some cases where there has not yet been compliance. I think this is probably a bigger topic in international law, not just in investor state. But at the end of the day, where you've had a fair process, you've had the chance to put your best foot forward, your evidence and your legal argument. If there is a finding against you, your obligation is to comply. And without compliance, the system cannot be credible. And if there is too much non-compliance, I don't think the system will work anymore. So that's something that is really critical to always remember and to ensure that parties, both states and investors, recognize that that is part of the deal when you use investor-state dispute settlement. So those are my two issues that I think we just need to constantly be on top of.
What's being done to address the compliance issue? Are there things like posting bonds? Is that used to some extent to help with that, or?
There's all sorts of mechanisms in the ICSID system, and again, this is perhaps a simplistic way to summarize it, but in the ICSID system, the drafters did something that I think was very interesting. You don't find anywhere else. They said basically an award that's final at ICSID, so you've done your first level tribunal, and if you wanted to, you've brought this to annulment, but once you've finished using the remedies available to you, it has the authority of a domestic court decision at the highest level. And so instead of having to go through and try and get recognition and enforcement, which can be yet another time, topic that takes a lot of time and money, you start with something that is admitted to be enforceable and ready to go. And then the investor or the state, if they're looking for costs, simply goes to any of the ICSID member states and it is enforceable. Now, that's not to undersell that it's still something you have to do, but that is certainly a step very far ahead of any other systems. And that's why actually when I talk about some of the concerns potentially of a court, not having that enforcement mechanism, I think could have some adverse consequences. So it's something states obviously will have to keep in mind and think about. In terms of compliance, certainly ICSID has just put out a paper about the extent to which there is compliance, and it is a question of always reminding the parties that this is part of the discipline, and you just have to keep doing that. The system has some of its own ways, I think, of ensuring this. I think a state that just never complies will find that their investment climate is affected. It may be that their investment ratings go down or discount rates are affected. The market slowly also sort of reinforces the importance of following the rules, but I think it's something that parties have to remember when they actually go into a case.
When you were talking about cost and efficiency, I was just wondering, were there any lessons learned through COVID that, where technology enabled sort of a more low cost expedited process?
Yeah, absolutely. I mean, one of the very few silver linings of COVID was we all had to get computer literate. And in fact, ICSID had the capacity. We had been working all along to sort of go more to electronic means. So for example, we went from, big bankers' boxes full of paper for filing to electronic filing. We were offering remote hearings before COVID, but it was not something that there was much take up on. As of COVID, we had to all pivot very quickly. And I know at ICSID, we did our first remote hearing 10 days after we were all sent home. And we all learned a lot through this process. And now there are a lot more remote hearings. We still find people have a preference for in-person hearings where you're actually at, the witness evidence, the meat of it. But there is a lot done now in using remote technology. And I think that, as I say, has been one of the few good things to come out of COVID. And we're seeing people increasingly comfortable with that, not requiring boxes and boxes of documents, able to have witness evidence. So that's been one of the good things, and holds out the promise of bringing down cost and time.
Okay, thanks for that. So we're now moving to the the last section, just your last thoughts, Meg, about the situation we find ourselves in today and ISDS. So we have entered turbulent times for international law, and Canada has always been a country that benefited from and advocated for rules-based international order. What do you see as Canada's place in the world and Canada's role in international economic law, and how might that evolve in the coming years?
I'm always surprised by how many people I meet who might be living in Paris or living in London, and then it turns out they're Canadian. You're like, oh, where did you go to school? And we sort of have this sort of Canadian reunion. But the point being, Canadians actually are very present in international investment law, and we have huge capacity. I'm also looking in particular at Canadians just generally in terms of their diplomatic skills. I don't know if you listened the other night, but Kirsten Hillman, who is Canada's ambassador to the United States, was being interviewed on CNN, and she has been speaking a lot about current events. She was one of our lawyers at JLT and did all of the negotiation and learned all of those kinds of skills many years ago. And I can name a number of people who have learned this and are really impressive Canadians who are in this discipline. And I think it's very much because we are aware that we are perhaps not the biggest or the richest. And so you have to really rely on your ability to negotiate, your ability to be smart, your ability to work hard. And we've always had this statement, which maybe sounds a little silly, but we punch above our weight. I think that's true. And in the kind of turbulent times we have right now, that's going to be more important than ever. So it's something I think that Canadians can be very proud of, and that we need to keep nurturing that ability and that capacity, because the world's throwing us some challenges.
We need that rules-based order, so we better be prepared to defend it.
Exactly.
What is your reflection on your career in ISDS and the state of international law today and respect for international law?
Yeah. I think, I mean, the first or the thing that comes to mind in particular is just how much gratitude I have, just how lucky I've been. I've had a career so far, and hopefully it continues on, but a career where I've been able to do so many interesting things with so many interesting people, to meet people in all sorts of different countries and hear different views. And I just think I've been so lucky and privileged to do that. So that's the first reaction I have. I think international law, and in particular international economic law, is getting more and more challenging. You have overlap of new fields. For example, international climate law is something maybe we wouldn't have thought about 30 years ago, and yet that now arises often in the context of investor state. You've got different fields of international law overlapping. You have problems that are more complex, and you have more actors, many of them coming to the table with different goals or different perspectives. So problems are tougher, and it just means we need to, sharpen our skills and stay on this, because I don't think there's a good option to a world, rules-based order. It just seems so logical to me. So I agree with you. We really need to do everything we can to make sure that we preserve a world rules-based system of law.
Thanks. And I'm just wondering, are there any lessons relevant to investment law from the experience of NAFTA, which then became CUSMA, and from CETA, and lessons from ICSID? Do you see that there's a moving away from IISD, at least between developed countries, or how is this? Where do you see that?
I mean, I know we hear this sort of in the popular media, but I think it's the opposite. We have an increasing number of states who are using international investment law, international investment disciplines. Certainly, it is one that has evolved. It's different than it was in the 1970s, but it is still very much present. And I think it's really important to remember, if at any time the world needs more investment, we need more innovation. I mean, just looking at the kind of dollars we need to deal with climate adaptation and mitigation, we need to encourage that kind of innovation and that kind of investment. So I don't see us going away from investor state. And I think if you look at the statistics, there are more cases, there are more countries involved in this. So that's sort of what you might hear sometimes, that it's just going to die. I don't think it will, but I think it's really important for us as a community to keep it fit for purpose. And that's, I think, the kind of efforts we've made in terms of reform, and hopefully they are effective. It's really important.
Yeah, I think the comment you made earlier about technology transfer through investment, I think is such an important one for addressing some of these big challenges we have in climate-related challenges, environmental issues, health issues.
Exactly.
Yeah. And then I have one last question for you, and that's about where you're going next. So how are you going to use this next phase of your career in ISDS to promote the system of peaceful dispute resolution to which you have already dedicated so much of your career?
Well, I'm very excited to be able to see this whole discipline from a different perspective now. I've seen it as counsel, I've seen it as Secretary General. So I'm very excited to be able to do this job right now as a dispute neutral. I'm hoping that everything I've seen and learned means that I will be able to be an effective and impartial arbitrator or mediator. I would like to be able to do some of the mediation work, which is a new field for us. And I find it very exciting to be able to do the arbitration work. So I'm hoping that I can give back in that sense in bringing what I've learned along the way to cases that are ongoing right now. And just staying in this world, I think, is a great privilege. So that's what I'm hoping to do.
That sounds great. And you'll keep learning, right?
Absolutely. Every single day. That's right. That's right.
That sounds wonderful. Okay, so I'm going to turn now to our colleague, Svetoslav Ivanov, to provide a comment. I did mention his background. He's a candidate for a Doctor of Civil Law at McGill University, and he's specializing in comparative and international private law. And he is a member of our board as a student member and one of the joint secretaries. So over to you, Svetoslav.
Thank you, Oonagh, and a special thanks to Meg Kinnear for generously sharing your insights and advice with us. It is truly a privilege to reflect on the remarkable career of Ms. Kinnear. Now, what stands out to me the most isn't just the impressive scope of her achievements, it is the profound impact she has had along the way. Her career, I think, is a great example of how embracing challenges, adapting to change, and just stepping into the unknown can lead to significant professional growth. I think that from her early work at the Department of Justice to her role as Secretary General of ICSID, the story of Ms. Kinnear is one of relentless dedication. Let us not forget that under her leadership, ICSID has modernized its rules for arbitration, conciliation, and fact-finding, while also introducing mediation rules. In addition, the Center collaborated with UNCITRAL to develop the codes of conduct for arbitrators and judges, which by itself, I think, is a significant milestone in the reform of investor-state dispute settlement. These accomplishments highlight Ms. Kinnear's ability to unite diverse stakeholders and drive meaningful progress. Even amid geopolitical tensions, Ms. Kinnear's belief in the system's role in promoting peaceful dispute resolution remains unwavering, and I was especially struck by her optimism about the future of ISDS. Now, it goes without saying that her reflections offer many interesting insights, so let me briefly touch on some of them and perhaps consider some of their implications. So the first issue I want to touch on is ISDS in trade agreements. The exclusion of ISDS provisions in the Canada-United States-Mexico Agreement, I think, marks an important departure from NAFTA's framework. Without ISDS, as Ms. Kinnear already said, investors must now navigate domestic courts or state-to-state arbitration. And both of these options introduce new challenges ranging from political sensitivities to questions of neutrality and efficiency. Cases like the Keystone XL pipeline arbitration demonstrate the limitations of legacy provisions and underscore the need for accessible mechanisms to resolve investor-state disputes. And this brings me to an important question. Can mediation be a viable alternative? The answer, I think, is promising. Mediation has the potential to be a less confrontational, more cost-effective option compared to arbitration. In fact, ICSID's move to establish dedicated mediation facilities, I think, shows just how much attention this approach is getting. But for mediation to truly take off, I think we need more than just infrastructure. We need a cultural shift, if I may say so. Both states and investors must be willing to embrace mediation, and we need to build the right expertise to make it work effectively. By integrating mediation alongside arbitration, ISDS can become a more well-rounded, a more flexible system for resolving disputes. However, making ISDS more adaptable isn't just about adding, just throwing it into the mix. We also need to address growing concerns about how ISDS interacts with broader policy issues, like, for example, environmental regulations. There is a common criticism that ISDS undermines environmental regulations, but in many cases, this concern is overstated. Take, for example, the renewable energy disputes against Spain. These cases actually highlight how ISDS can hold states accountable to their commitments. At the same time, we must ensure that the system protects a state's right to regulate in the public interest. The Philip Morris case is a great example. It reaffirmed the state's ability to enact public health measures. But looking ahead, aligning ISDS with the public interest also demands greater transparency within the system. So the balance between transparency on one hand and confidentiality on the other hand remains one of the big challenges in ISDS. While confidentiality is important for disputing parties, openness is what ultimately reinforces trust in the system. We have already seen real progress with the Mauritius Convention, as Ms. Kinnear said, and the updated ICSID rules increasing public access to information. And speaking of trust, there is another issue that often sparks debate, and that is, of course, third-party funding. Some argue that it encourages frivolous claims, but the evidence doesn't really support that. When properly regulated and disclosed, third-party funding can actually make arbitration more accessible, giving smaller investors a fair shot at justice. Instead of undermining the system, it has the potential to level the playing field and promote greater inclusivity. But the key is, again, responsible regulation, ensuring that it strengthens rather than compromises the integrity of ISDS. Now, the road ahead isn't without obstacles, but with thoughtful reforms, we can ensure that ISDS remains a fair and reliable mechanism for resolving disputes in the years to come. Now, speaking of reforms, there are some very ambitious proposals on the table that could reshape ISDS entirely, and Ms. Kinnear already touched on them. So proposals like a multilateral investment court and the introduction of an appellate mechanisms are currently under discussion by UNCITRAL Working Group 3. So if implemented, they would lead to the establishment of new institutions with the potential to significantly alter how investor-state disputes are resolved. While the negotiations are progressing, some fundamental questions, in my opinion, remain. For example, which reforms will states support or resist, and how will these reforms, in particular, how will they interact with existing treaties and long-standing practices? And how will these interactions evolve over time, shaping the broader dispute resolution landscape? Those are some of the issues I'm concerned about in particular. Now, Ms. Kinnear also highlighted Canada's leading role in the global legal order and the importance of preparing the next generation of professionals. Canadians have made remarkable contributions to the field, as she said, and there are many opportunities for emerging international lawyers to help shape its future. So her advice to aspiring professionals is very important. So we can outline just a few of her points. So, for example, to embrace languages, because fluency in multiple languages isn't just an asset, it is necessary for navigating the diverse legal and cultural landscapes of international law. Second, to get those skills that you need, we need to seek international opportunities. And finally, to pursue your passion, because international law isn't just about theory, it is about making a real impact. Whether it's shaping policies, resolving disputes, or advocating for justice, this is a field where I believe we can make a real difference. So it is encouraging to hear that progress in diversity and inclusion is being made. And for those of us who are looking to build a career in international law, now is the time to step up and seize those opportunities. So let us take Ms. Kinnear's words to heart, whether about the importance of preparation, the value of building relationships, learning all those skills that we need in litigation, negotiation, or just simply to embrace change and strive to contribute to this field with the same passion and dedication as she did. So her career serves as a powerful reminder for all of us to approach international law with passion, dedication, and a commitment to excellence. I am very grateful to Meg Kinnear for inspiring us, and to all of you for your attention. That is all from me, Oonagh. Thank you.
I just want to say thank you. It's very, very kind of you. And
Yes.
I'm blushing.
Those were lovely words and very, very helpful summation made by you, Svetoslav. I actually wanted to turn to you, Meg, if you wanted to say a few words, just commenting on that. From my point of view, it's just really nice to have this combination of you talking about your career that you've been through, where you are at this stage, all the developments you've seen, and then Svetoslav just on the brink of, defending his dissertation and clearly very passionate about the future of ISDS.
I think really there's two things. Number one is I am just every day impressed by this new generation who have so many skills going at this. I think they're absolutely fabulous. So I think investment law and international law are in very good hands for the future. And otherwise, I think hopefully one of my skills is to stop while I am ahead. You've said so many nice things. So I just will say thank you so, so much. I really appreciate that. Thank you.
Thank you very much, Svetoslav and Meg. So with that, I do not see any questions I do have one question in the chat. Look at that. Let's see what we have. Oh, it's Barry Leon is writing a question. I'll read it to you. He's got three questions. Number one, what do you see as the main impediments to the mediation of disputes between state parties and non-state parties? A, impediments on the state party side, and B, impediments on the non-state party side. How can they be overcome? And what about transparency in the interests on non-participants in the dispute and the mediation? I can read the second part if you need it later. You're muted.
I mean, Barry's quite right. Right now, we are at early days, and I think more than anything, we need some success stories in terms of mediating investor-state problems. Part of this is an education issue, so that parties know that it is available and what it would involve. Part of it is difficult, obviously, for a government in particular, I think, to mediate, Governments worry about whether that will be seen as compromising, whether they will have the authority behind them at the end of the day, how they can implement this. So I think one of the things that's important is for governments to get their head around this. I think there are a lot of ways to do this, and having an approach that says we will mediate where possible is really just an additional option. You don't lose anything from mediation. And I think states are starting to realize this is very much complemented by the Singapore Convention, so that you can make a mediated settlement effective. So it's really getting states to understand this is a good option. You do not lose anything. If you want to, mediation depends on consent of both parties. So if at some point you don't consent anymore, you can go back into the arbitration system. So having a better understanding of that and being willing to give it a try, I think, is important. And we're starting to see some states who are willing to do this and interested in doing this. So I think, as I say, having some success stories is really going to help add a willingness to try mediation.
And what can you say about this challenge of the transparency issue in mediation?
Yeah, it's an interesting one. I mean, obviously, most people say, of course, investor-state arbitration should be transparent. It is a difficult question when you get to mediation, where one of the real strengths of mediation is that it is confidential. If it doesn't succeed, nobody feels that they lost anything in terms of their case preparation or their profile. And this is something where it was discussed, certainly, at the ICSID rules amendment, other places. And I think the decision was mediation should remain confidential. The fact of mediation is not confidential, but the contents of it are confidential and should remain so, to make sure that everybody feels they can fully put their position forward and that they won't be prejudiced by doing that.
Thank you for that. I see no further questions, so it's just left to me to close this event and grant to all of you an extra 15 minutes of your life to get on with all the things you need to do. So on behalf of everyone on the webinar, and the International Law Association of Canada in particular, I'd like to thank you, Meg Kinnear, and you, Svetoslav Ivanov, for providing so much useful information today. I thank the audience for the questions, in particular, the questions brought to us through young Ojamid. That was really helpful. And of course, Barry's amazing help with all that. So I just ask you to please follow ILA Canada, the International Law Association of Canada, and the International Law Association on our respective websites and social media for our next events. You're most welcome to join this exciting and supportive international law community at ILA Canada. And as I mentioned earlier, we have free membership for students. So with that, I wish you all the best. We'll be doing more events in the year, so just stay tuned to see what's coming up. All right. Thank you so much, Meg. Thank you so much, Svetoslav. Good night.